Part 1. California Law on Secession. Any California resident can file an initiative with the California government to propose a new law. An initiative that would have put a question on the ballot for voters to consider if California should be independent from America has been submitted and accepted 3 times by the California government. Using this process, 3 separate California attorneys general have approved separate initiatives calling for a vote on a Calexit. The attorneys generals have struck down other initiatives as unconstitutional, but yet did not strike down this one. State Attorney General Kamala Harris had filed a lawsuit in March to block the initiative, arguing her office should not be required to formulate a ballot description for the measure, which states that gays and lesbians must be put to death by bullets to the head or by any other convenient method. The Calexit initiatives are hosted online by the CA Secretary of State and can be copied and resubmitted at any time with text that we know was already approved. Once you file the initiative, you are told a few months later you can collect signatures. If you get enough signatures, the initiative goes to a vote. On the ballot, you can ask California voters if they want California to secede. Californians would need to vote over half in support of the question for the measure to pass. This act alone doesn't make California independent. Part 2. Federal Law on Secession. The U.S. Constitution says that for legal interpretation of the law, that the Supreme Court should do that. SCOTUS has only looked at secession one time, in Texas v. White, and said it is legal with consent of the states. Most of the time, the media focuses on the part that says you can't unilaterally secede, which is true. But this other fact is also true. Texas v. White was decided by Salmon Chase, who was directly appointed by Abraham Lincoln. Additionally, Lincoln himself said in his first inaugural address that this form of secession was legal. Again, if the United States be not a government proper, but an association of states in the nature of contract merely, can it, as a contract, be peaceably unmade by less than all the parties who made it? One party to a contract may violate it, break it, so to speak, but does it not require all to lawfully rescind it? It follows from these views that no state upon its own mere motion can lawfully get out of the Union. I shall take care, as the Constitution itself expressly enjoins upon me, that the laws of the Union be faithfully executed in all the states. Doing this I deem to be only a simple duty on my part, and I shall perform it so far as practicable, unless my rightful masters, the American people, shall withhold the requisite means, or in some authoritative manner direct the contrary. The Chief Magistrate derives all his authority from the people, and they have referred none upon him to fix terms for the separation of the states. The people themselves can do this if also they choose, but the executive as such has nothing to do with it. When Texas became one of the United States, she entered into an indissoluble relation. The union between Texas and the other states was as complete, as perpetual, and as indissoluble as the union between the original states. There was no place for reconsideration or revocation except through revolution or through consent of the states. Additionally, 3 separate California attorneys general have approved of this legal interpretation of Texas v. White, citing it in their approval of Calexit initiatives. Additionally, the top constitutional scholar in California, Erwin Chemerinsky, said a simple majority vote of Congress could be enough to suffice for CA independence to be legal. Additionally, there is a reason to believe that America has to recognize a vote for independence from California. When the United Nations was formed, America signed a treaty to make it exist. In that treaty, the UN Charter, it states in Article 1, Section 2, that all states have to support the principle of equal rights and self-determination of peoples. According to the Supreme Court, treaties supersede all domestic law, which means the USA government recognizes the right of self-determination, or the ability to become a nation-state. Republicans across America hate California. Take a look at this recent poll. 48% of Republicans went so far as to say the state is not really American. Additionally, Republicans held a convention recently where they made California the official enemy of the party, and numerous polls have been taken over the years, showing conservative support for a Calexit. Kimberly Guilfoyle, a campaign advisor for the president and Donald Trump Jr.'s girlfriend, took aim at California during her speech on the first night of the 2020 Republican National Convention. Part 3. Bringing it all together. The initiative suggests that California appoint its own representative with the express function to appeal to Congress for a vote to leave. Because of Hiram Johnson in 1911, over 100 years ago, Californians directly have radical power in the initiative process. The Economist magazine called California the most powerful direct democracy in the world because of the California initiative process. We can ignore every politician in Sacramento not supporting this vote, and it can still pass and become law. And by law, the California government will be compelled to fulfill the elements of this new law. California is also unique, in America and the world, in treating every successful initiative as irreversible, unless the initiative itself says otherwise. Of course, many politicians will obviously support the idea of California independence if the initiative is passed by a majority in California, and their support will be welcomed by all lovers of independence. Republicans in Congress will vote for the measure to some degree. Hopefully, Republicans approve the request. California accepts the offer by virtue of the public initiative that passed a vote, and legally, a path is cleared for California to begin formal negotiations for independence. The timeline could look like this. Step 1. Filing the initiative with the Attorney General. 2 months till approved to collect signatures for initiative. 5 months, 180 days, to collect signatures from public to qualify initiative for the ballot. 3 months, 131 days. Later, if enough signatures collected, the initiative can be placed on the ballot or next election after. If Californians vote for the initiative once it is on the ballot, it could be enacted immediately, and representatives sent to Congress to petition for independence. The only study on peaceful initiatives says that they usually take 2 4 years of negotiation to finalize the details. This is because politicians have to be re-elected, the study argued. Years later, this is exactly how Brexit played out. With Get Brexit Done as his slogan, Johnson led his party to a landslide election victory. He succeeded where his predecessor, Theresa May, had failed in getting a deal passed in Parliament and finalized with the Europeans. 2 in 4 years total is incredibly fast as far as creating new nations goes. While it doesn't stop any bad ideas from the federal government being enacted in California immediately, it would signal to the federal government that perhaps it should not be as rough as it could be about enforcing rules, considering the state is about to have a credible vote for secession. Additionally, holding a vote will rally the California public and their elected officials to resist any policies from the federal government deemed horrible by Californians. California resisted greatly the administration of Donald Trump at both the people level, up to shutting down entire freeways, and government level, and it would do that again on steroids. Part 4. Can't lose. If there aren't enough votes for the initiative to pass, then it doesn't, and California stays. However, the initiative also requires the creation of an exploratory research committee on the topic of how and if California could survive independently. This is called a Blue Ribbon Committee, and California does this sort of thing all the time to create new legislation from emerging issues like legalization of marijuana to regulation of children's education. In Scotland, they did this and called it the Calman Commission. It would be years later before Scotland would have a vote to become devolved from England, and later a vote for full independence. But experts there say it all started with this official report from an official government research project that took the subject seriously. Everyone in Scotland read the Wee Blue Book, as it was called. This initiative would create a commission here in California of experts to report on all aspects of a potential Calexit. A list of experts who have made public contributions to the debate already is prepared and available to the public now in the Golden Guide to Independence. California has a large and well-educated population. We can fill a commission of experts who report the facts of how CA could survive and why it could thrive independently. Even if the report is critical of the venture overall, it will have to admit many facts that are currently unknown to the public about how viable this idea is. That is what happened with the Calman Commission. What only a few individual experts knew, the commission made widely available, and it caused an explosion in public discussion about independence in Scotland. Something happens signaling American decline that reignites interest in the idea of Calexit. When the U.S. Senate refused to hear information about Brett Kavanaugh before approving him, interest online in Calexit went up. When Roe v. Wade was overturned, 3 newspapers published their own articles talking about a potential Calexit. And of course, when America elected someone like Donald Trump, support for Calexit ballooned to 32% overnight. Any person can file a Calexit initiative with the California government. If you filed, your friend can file next time. You can't file multiple initiatives of the same thing by the same person. Californians try again to have a vote and send a representative to Congress. The California government does something that is seen as offensive by many Republicans across America, like it does naturally all the time. Examples of times California's government or its citizens have upset many red states with legislation, or actions were pass a law for transgender rights that benefits AIDS victims, or against access to guns, or spent money on billboards in southern states telling people that abortion should be free and that this message came from California, and of course banning CA sports teams from playing with teams in Republican states. Republicans vote in a higher percentage to let CA leave. The cycle repeats as the USA continues to politically divide to levels, according to some professors, not seen since before the Civil War. In fact, we're probably more polarized than we have been at any period in American history, with the exception of the Civil War exception, but it's not a big exception. When things degrade in America, and Californians are scared of what they see the nation becoming, or when something happens in America that shocks the sensibilities of Californians, like the election of Trump, or the appointment of a super-conservative Supreme Court, Californians will refile the petition and try again. This has been a winning strategy for many once radical ideas. For comparison, the right for women to vote was first proposed in Congress in 1878 and not passed until 1920, but each attempt brought women's rights advocates closer to success by raising awareness. Additionally, marijuana legalization passed by initiative in California. It took multiple tries for the initiative to finally be approved, but with each campaign, even though it didn't pass, they increased public awareness, public education, and ultimately, public support for the idea. Many Californians shifted in support of marijuana between the first and last time the initiative was filed to legalize weed. Also, a key reason that the marijuana initiative passed was because an angel donor gave millions of dollars to help hire signature gatherers so that initiative would qualify for a vote. The initiative to ban gay marriage also received an angel donor who spent over $1 million in California to stop the initiative. Both initiatives received angel donors because they had been promoting this idea for years, and these two billionaires heard about it. Having angel donors support your initiative so that it qualifies for the ballot is completely legal and happens with almost every initiative that passes in California. Part 5 in summary. File the initiative that is publicly available. If it doesn't get enough signatures, file it again and use it as a chance to educate more people. When you get enough signatures, it goes for a vote. If you get enough votes, it goes to Congress. If you don't get enough votes in Congress, file it again and use it as a chance to educate more people. If you get to Congress and Republicans vote for it, start negotiations for independence. If you get to Congress and Republicans don't vote for it enough, file it again and count on America continuing to decline and California to continue to upset traditional Republicans in most American states.